Welcome back to our special focus on the Senzo Meyiwa murder trial. Let's look ahead. What will be the impact of the second docket? What possible explanation could the NPA have? Will this have an impact on the integrity of the National Prosecuting Authority, actually? I still do have all our guests with me at the moment. I just want to ask you, Ntabiseng Dubazana, in terms of what you heard from Kelly Khumalo's attorney, Magdalene Munsami, saying that she's still going to hear from the NPA on whether or not, or the state, on whether or not this docket number 375 actually is authentic.
Yeah.
I got a bit confused. Maybe you can assist me with that. Why would the state bring forth a document or documents that they still need to check authenticity on?
I think that's why I was a little bit confused there. But if I were to assume, I would think that my colleague was saying that perhaps to see if there's a prima facie case against her clients, whether the state believes there's any merit in the docket to proceed with the charges against her client and the other people that were within the house when the incident occurred. But when I was listening also to my other colleague, I think it's Mr. Venter, what he said, I agree with 100%. Because if there's an indictment already that has already been there, it means the state already believes there's a prima facie case for them to proceed with the matter. It means the matter ought to have been placed on the roll for whatever charges are within that docket. Whether the docket is for murder or defeating the ends of justice or whatever the case may be, it means that the prosecution, the NPA, believe that there is something to answer to. The accused had something to answer to in that docket. It's just that the indictment was not signed and nothing happened about it. But it's already creating doubt, I believe, in the head of the presiding officer to wonder, okay, why would it be that this docket never came forth or nothing happened about it until now? And why is it being, in a manner of speaking, joined or consolidated with this one, but in a manner as if it's being brought forth as evidence? That I think that is the main crux of the issue. Why is it being brought as if it is part of disclosure when it should have been an issue of consolidating the two dockets prior to the trial commencing? So there are, it is then Kelly Khumalo's attorney can then have disclosure as well in order to represent her client accordingly with whatever charges are within that docket. So if like my other colleague had said, that it should be accused person should be the current 5 and the others that are in docket 375. But that should have happened in the beginning, not in the middle of a trial. Because what I believe might probably happen now is that come tomorrow, if the DPP decides that, okay, we're not proceeding with this matter, then what am I doing as defense attorney? What am I doing with this information from docket 375? Why is it being disclosed to me? And even if there are witnesses, but then there are witnesses in the form of a docket, I'm already going to have issues with that because they're supposed to be joining my client in the accused dock. So I think when we finally come back tomorrow, we should have a clearer way of what's happening. And if it means that the accused persons from 375 are being charged as well, or whatever the case may be, which hasn't happened as yet because they haven't been charged with any crime as yet. But if they're going to be joined or consolidated to this crime, to this particular matter, it means we might see the trial start in de novo. Because remember, Kelly Khumalo's attorney and others have not had the chance to cross-examine this current witness that is before court. They haven't had the chance to sit within the evidence in chief in order to prepare themselves for cross-examination. There's a whole can of worms that we're going to be dealing with.
Absolutely. Slee, hearing that there was this indictment, you are in communication usually with the defense lawyers of the 5 accused, whether it be Mshololo or Difo. I wonder what they are thinking, if they've ever told you. And I know you actually even tried to get a hold of the NPA to try and clarify what is going on with these dockets. And, hearing Ntabiseng say that, okay, one is a docket, the other is also a docket, but now one is being brought as evidence. Have they said anything? Obviously, they don't want their clients to face these charges.
Of course, the defense is going to do everything they can in order to try and exonerate their clients. We're seeing that in terms of them poking the holes, in terms of how the crime scene one was handled, but also now in terms of bringing in this second second docket. In fact, it's no secret, this docket, Masego. In fact, as far back as Advocate Madisela Tifo's cross-examination, that is when it was first introduced in terms of this affidavit by Musia that he had deposed in connection with docket 375. Now, what we understand, the defense is saying our clients have been prejudiced because this information was not disclosed. In particular, Advocate Mshololo, as she's continuing with her cross-examination, she's saying the fact that the state has known about this even as far back, from what we understand, according to the state, March the 23rd, which is when they had requested this docket from the investigators. Why was it then not given to the defense to say, look, here is another docket in connection with this case? She's saying, the Advocate Mshololo rather, is saying our clients' rights at this point are being infringed on. We are not being given the opportunity. We have actually not received full disclosure as to what is happening with this case, yet our clients have been charged here. She even went as far as to say we should have more people then in the dock facing the charges before the 5 men accused at this moment.
Let me come to you, Advocate Munsami. I saw you, nodding your head in agreement as Advocate Dubazana was speaking to me there about why the state doesn't just add everybody together, all its accused, so that even your client, her family members, etc., have the chance to cross-examine the alleged evidence that is in this docket and be able to clear their names. Am I correct that you were agreeing to that, or were you agreeing to another point she was making?
She's muted.
Sorry, thank you so much. I just want to confirm the following. The major thing that should have been done in terms of outlining the state's case should have been to have brought the eyewitnesses on the property at the scene as the first witnesses. And then we would be able to understand, okay, what is the evidence? Now, in light of the fact that we don't know where 375 emerged from at this point of the trial, because this witness has been under cross-examination and examination for quite a number of an extensive period. And indeed, the one thing that would then raise concerns for me would be, how then do we proceed from a point, should my client then go from being a witness to an accused? Now, I want to say the following, and I want to reiterate it. My client has been awaiting her day in court. And this is, I've been saying it ad nauseum. However, the reality is that we are now opening grounds of speculation and closing a space for fact and for predilection of evidence to be presented. The one aspect of evidence, despite the competency or incompetency of Sergeant Musia, as indicated earlier, there's the aspect of ballistic forensic evidence which must be presented, which is critical, simply because that will then dispute the issue of what was being raised by Senzo Meyiwa regarding the fact that the 5, and if in the instance of a family then having a watching brief, who then becomes the defense attorney, not wanting to bring to book the accused that are in the dock, or to establish really the facts of the matter. I would find that, yes, I'm in agreement to the extent of the speculation around then how would it be resolved and what would be the implications moving forward for those that may or may not be established in terms of 375. My major concern, and that my major point of agreement, I think, on that issue is the unsigned docket. There has to be a reason that 375 was not signed, because if you are speaking about defeating the ends of justice and there are an additional number of accused as alleged, then let's just open up the matter and the trial to be able to establish what then were the events and versions, the statements of all players in this matter. You can't have 5 accused with confessions sitting in a dock and not wonder that they came out of what set of circumstances. It can't be a default of the competency of forensics It can't be a default on the competency of ballistics. It can't be a default on the competency of the entire judicial infrastructure and state apparatus. There has to be something amiss. And this, for me, I think, is where the rubber hits the road.